Hello, and welcome to this episode of Behind the Docs, presented by Evan Guthrie Law Firm. I'm attorney Evan Guthrie, and today we're going to go over the last will and testament of Jose Onfroy, better known as rapper XXXTentacion, who was gunned down and murdered in June of 2018 at the age of 20. And before that, in November 2017, he was able to make his last will and testament and also living trust. So today we're just going to go over his last will and testament, which was probated in June of 2018 in Broward County, and just go over the high points. So the first part is just saying, sort of the preamble part. It's going to say that he's a resident of Broward County, and that's just saying that whatever county you live in, in this case Florida, as you're saying, just a resident of, so sort of establish you as a resident in that state and able to make a will. In Article 1 is going to be identification. So it just goes over some of the key points that may materially affect the will as far as family relationships and dynamics. So A is marital status. So at the time he made his will, he currently did not have a spouse or was not married. But more importantly, B is children. So at the time he made his will, he had no children. But reportedly, there may be a child that he fathered with a female girlfriend that may be his. So it hasn't really, the paternity has not been established yet, but just based on reports, that may be an issue in the future. So the way that would happen is potentially the mother of the child would be able to make a claim on behalf of the child on his estate. And that would work out is potentially he would get the share of the estate he would have without the will in place. So that's just something that potentially could happen as far as that. So it's just a good idea anytime you have a change in your life situation and you have one of these major events, either you get married or you have a child, it'd be a good opportunity to update the will just so you can still control what happens. So there's really no sort of statute or law that says you have to give anything to your children. So if he wanted to potentially exclude his child, he could still do so by making a new will. That's just something you'd be able to do. But in this case, since he passed away before the child was born, he didn't have an opportunity to be able to do that. So we're sort of set in stone at this point as far as that dynamic. All right. And then Article 2 is going to be memorandum. So it's just saying sort of the personal property memorandum. It says that any sort of items, any personal property he wants to give away, is you can just have a separate piece of paper, a memorandum that says just who he gives it to. So in this case, tangible would be kind of like jewelry or anything you can sort of put your hands on. It doesn't have a title like a house or a car. And just, he was able to sort of have the legal authority or capacity to do that. It just gives him do that. So you always don't have to update your will anytime you want to give somebody anything specific like that, anything that's tangible. So everything else is going to be in Article 3. So this is going to be disposition to trust. And in this case, this kind of will is what's called a pour-over will. So it's going to reference the Jose Onfroy Living Trust. So this is usually a will that you make the same time as you make the trust that just says that everything's going to go into the trust. So if there's anything that's still titled in his name that would be controlled by the will, it just moves into a trust. So that's just sort of make sure that everything is be able to go into the trust without anything going to probate. So that's just kind of what the main idea of the pour-over will does. And then it just goes to everything's administered, distributed in accordance with the terms of the trust. Article 4 is going to be specific bequest. So for any reason the trust is not in existence, so it can always be revoked or anything can happen to it. Or if it's not funded, it just says that everything that he has just goes according to the terms of the trust. And it just says that he has contingent beneficiaries, whether it be the personal property memorandum or the personal representative will be able to sort of decide who everything goes to and be able to sort of divide everything up. So that's kind of their responsibility. And then it also sort of references any minors to be able to do that. So, or contingent beneficiaries. So they would be able to do that. So the minor, in this case, might be his little brother that might be a beneficiary and still be a minor. So that's something that's just sort of be planned for and is addressed in this part of the will. So Article 5 is going to be contingent beneficiaries. So for any reason the trust is not in existence at the time of his death, for that, all residue of the trust of the estate will be distributed according to the same beneficiaries, the same manners as provided by the trust. So, and then if the trust were still in existence, so that means that even if the trust is not effective, it's going to be a little bit more detailed as far as how things are divided up as far as assets. So it's just going to be say whatever's in a trust, this will is going to be distributed the same way as far as the will, any assets. So more than likely that's not going to be the case, but it's just good to have it sort of as a backup just in case, to make everything safe and everything that goes to it, to the person that you want to go to. It's just contingent. So Article 6 is probably going to be the next most important part, is going to be the personal representative. So this is going to be the person in charge of the estate. So you get to nominate who you want to be in charge of the estate. In this case, X appointed his mother, Cleopatra Bernard, to be personal representative of the estate. So that means that she's going to be in charge of administering everything, making sure that everything sort of goes to most likely herself and her son or X's little brother. They're probably the most likely beneficiaries of the estate. But she gets to be in charge of all that. And then also, this is most likely going to be an ongoing estate. So it's not something that where all the assets are just distributed and the estate is closed probably within a year or so. It's going to be an ongoing estate because X's estate is probably going to keep earning as far as image, license, music publishing, any unreleased albums, any sort of streaming deals, and any licenses as far as his image or sounds. It's going to keep earning long after his death. So potentially his entire mother's lifetime is still going to be having earnings come in for the estate. So that just gives her the power to sort of be in control of all that and just to sort of direct the direction that she wants to go. And then the backup personal representative is you get to nominate the primary, which is going to be his mother, but the backup is going to be Michael D. Wild, and he's an attorney in Broward County, does estate planning and wills and estates. So he's most likely the person that drafted this will and sort of the next person in line. So if for whatever reason his mother is unable to act, Michael D. Wild will be the backup personal representative. And for a reason he's not able to act, there's a second backup, which is going to be Wild Fleece and Partners PA. So that's going to be the law firm that Michael Wild's a part of. So for a reason he's not individually able to act as personal representative, his law firm would be the backup. And that could be sort of anybody in the law firm could sort of step up and administer the estate at that point. And then bond, this is going to be unsupervised administration. So in most cases, if there's no will and the family members don't waive bond, is potentially a bond would be, it's kind of like an insurance of the estate to make sure the personal representative does their job properly. And then for a reason they don't do their job properly, then there's the sort of insurance or bond to make sure that's sort of made whole as far as the beneficiaries. And in this case, it's sort of an unnecessary expense of the estate because you have a sort of a trusted person in place, whether it be his mother or the attorney, which is held to a lot of different standards as far as an attorney. So let's make just unnecessary at this point to have any bonds. It's kind of an expense that could be going to the beneficiaries instead of an estate expense. So it's just waived at this point. And then C is going to be expenses and compensation. So it says every personal representative should be reimbursed for any reasonable costs or expenses. And then also says they could be compensated for any times in accordance with the Florida statutory rate prevailing at such time. And then any amount that's not exceeding the customary prevailing charges for service similar. So in this case, for a reason, if X's mom is the personal representative and she has to travel or she has to hire an attorney or a CPA or an accountant, if she just gets reimbursed for any out-of-pocket money that she has to spend on the estate. So it's just kind of, if she's a beneficiary, it really doesn't matter that much because pretty much it's money that's going from herself to being reimbursed. Probably where it comes more into play is if the attorney, Michael Wild, is the personal representative, is for any upfront money that he has, since he's not a beneficiary, is he just gets reimbursed for if he has to travel, or he has to be able to hire any outside CPAs or any other experts to do anything as far as the estate. He would just get reimbursed for that. And also that means that he could charge his legal fees as far as being able to be an attorney for the estate. So it's just saying that for every sort of typically hourly fee that he normally charges is going to be reimbursed from the estate. So he's not a beneficiary of the estate, most likely. So he would just be able to be the professional administering the estate, and he'd be able to sort of be reimbursed for his services. D is going to be ancillary personal representative. So for any reason, if money or debts have to be settled, or lawsuits have to be settled in other jurisdictions, like let's say New York or California or Texas, is that X's mom or Michael Wild be able to be appointed as personal representative in those jurisdictions, and it'd be the same sort of powers in those jurisdictions. And then for every reason, E is multiple personal representatives. So in this case, if there has to be multiple representatives, and probably what the way this would happen is the second backup is the law firm being appointed as the backup personal representative. And for a reason, they have to nominate 2 people. Those 2 people will sort of have the same authority to act as personal representatives. So let's say it's a kind of a busy law firm. You need one person to sign something, they'd be able to sign something and then act as personal representative. So it's just kind of making sure that's covered. So F is going to be actions by co-personal representatives. It just says that kind of like they're able to have the authority to act alone or to independently. So it's just saying that you don't need both personal representatives to sign something. It just makes it more efficient and a lot easier. So Article 7 is going to be personal representative powers. So it just gives the personal representative, X's mom or the attorney, the power to be able to administer the estate. So it just gives them sort of full authority to do whatever they ever have to do to manage the estate and make sure that it's administered properly. And then a lot of times it's just going to be making sure they have the power to sell or release anything that's going to have no liability. So they don't want to make sure that they don't get sued for anything they do. They can borrow money. They can invest in properties or real estate. They can enter any real estate sort of transactions. So whether this would probably be very helpful because you have to sort of have ongoing record deals or any kind of licenses that have to be renewed over time, is that the executor would have the legal authority to do this and make sure that that's kind of the transactions that they have to go on as far as ongoing estate. And then it just sort of goes over a lot of the different powers. Another one is going to be digital accounts and digital assets. So this is something that's come into play a lot more recently, especially in X's case, is he's going to have a lot of digital assets as far as his likeness, whether it be like a Twitter account, YouTube account, or anything that was on his phone. So a lot of times it says messages, emails, documents, audio. So a lot of times it's going to be recording, sounds, social media content. So all this has value, and it may not be sort of controlled by the user. So let's say that for a reason X was controlling his own social media account, and he had a password, but he didn't share that password with his mother or anybody else. He sort of kept it to himself. Is the personal representative, if they showed this will to Twitter or YouTube, they should be able to access his accounts and be able to manage that as far as making sure that it's managed properly, add new content, delete content that they don't want, and then just make sure to do that. So it's good, important sort of provision to have in a will nowadays, especially someone that's active and has a brand or social media presence. It's going to be something that's good, and especially the musical artists that may have a lot of times recordings on their phone, and so they're inspired to make a sort of on-the-spot recording on their phone. They do that, so it's just able to have all those programs and everything have digital access to it, or potentially could be locked out because, again, they just want to make sure the users are protected privacy-wise, and there's a lot of red tape and a lot of forms you have to go through if you don't have this in place. So it's good to have this provision in place, especially in X's case. And then, again, just making any sort of distributions. This gives her personal representative the power to do that. And then Article 8 is going to be miscellaneous provisions. So survivorship provisions. This means that everybody, the beneficiaries, survived 30 days, and that's happened. So you don't have to worry about that. Spend for provisions means that for any reason there's debts or anything that there for the beneficiary is potentially those creditors would not be able to attach anything. So let's say that for a reason the personal representative was in heavy debt, or the beneficiary was in heavy debt and they owed money to like a credit card company or another debtor, is potentially those beneficiary funds could be kept away from them if they have this provision in there. So it's good to have that in just in case. Arbitration of disputes. So for whatever reason, if there's a dispute between beneficiaries, that means that there's going to be an arbitration as far as it'll be final and binding. So just make sure, in this case, probably what the one that comes to mind is, again, the child being represented by the mother of the child. Is they might have to come up with some sort of agreement or settlement based on how much the estate wants to give the child, if there's a potential child in place, or any other sort of type of lawsuits or estate litigation against the estate is going to say that they want to go through arbitration and then sort of get it over at that point. So it's kind of like a mini trial without the jury or judge. You just have the arbitrator that makes the final decision. So it's kind of good to have that in there if you want to make sure that everything's sort of controlled and doesn't go sort of sprawling litigation everywhere. So descendants is going to talk about descendants, a kind of the legal definition. So it just goes over descendants. So in this case, the first degree descendants would be a child, and then it just goes over sort of what that is. So any lineal blood descendants, so that'd be potential children. And discretion, so it just means that you're going to have an incapacitated to have a little bit more legal definition. So it's just good to have it in there as far as that goes. And it goes over what heirs are in per serpes. Again, X potentially had one child. If he does, that child passes away, potentially their children would be able to have the estate. So it just goes over there. Article 9 is going to be the no contest clause. So for any reason, any beneficiaries wanted to challenge anything that's in the will of trust, is that potentially they'd be able to lose whatever they did have based on the challenge. So let's say that whatever reason a family member wanted to get the full estate and they were entitled to half the estate, is if they challenged for the full estate, is potentially they could lose their half estate for challenging. So it's just meant to sort of chill any sort of challenges or estate litigation for having the spend provision or no contest clause and that. So it's just make sure that the administration is a lot easier. And then this is going to be the witness part. So kind of what's interesting about this part is normally the testator, they says, I sign my name, execute this as my last will and testament. But in this case, it looks like his mother, Cleopatra Bernard, was actually signed for him as power of attorney. So more than likely, she had a power of attorney to handle his business affairs and his personal legal affairs. And that gave her the power to sign for his will if that was one of the listed powers under the power of attorney. So in this case, she signed his will. He didn't sign his own will. But again, that's more than likely still going to hold up in court as far as a binding document, as if she was given the authority to do that. So that's going to be able to do that. And then you see the date of the death, or the date of the execution of the wills is the 7th of November 2017. And kind of, again, like the motivation was sort of reported that he knew kind of the lifestyle that he had, as a lot of people were jealous and a lot of enemies, that potentially something like this could have happened, that he may have had the need to have a will a little bit more than your average person would have a will. So he sort of understood the need to have a will and the importance of having it. So that's kind of why he had a will at age 20, is he he knew something like being shot could happen. So it's just kind of motivation that if someone does have sort of a lifestyle or a risky profession, whether it be like a rapper or some other kind of risky profession, is to have an estate plan in place. So definitely good that X did have his will in place and trust in place to be able to protect his family, because it makes the administration of the estate a lot easier, making sure that you have someone that's clearly in charge and a trusted person in charge, whether it be a mother or a sort of a family attorney that's in charge of doing that. So, and that's going to be the will of XXXTentacion. And thank you for joining us today.